All right, good afternoon, everyone. We are going to get started because we only have an hour today. So we'll go ahead and get started. Good afternoon and welcome to the advisory committee meeting for the 2023 marijuana retailer tax compliance. Thank you for taking time out of your busy schedules to attend this afternoon's meeting. My name is Nicole Blase and I'm the rules coordinator for the OLCC. A few housekeeping notes before we get started today. This meeting is being recorded. For those who are joining us virtually, please ensure that your phone or computer is muted unless you are speaking. Only invited committee members will be a part of today's conversation. Members were selected due to their level of interest or position within the community. With that in mind, we ask that each of you serve as goodwill ambassadors to the discussion so that you may represent your constituency professionally. Please be courteous to other committee members so that we don't have multiple participants speaking at once. You may use the raise hand function in Teams, or if you are calling in, please interject when appropriate and we will call on you in order. Non-committee members will be able to tender comments during the public comment period and the public hearing. Committee members, please state your first and last name when you make a comment. Okay, today is Tuesday, September 12th at approximately 1 p.m. Many of you are familiar with the rulemaking process, but for those of you who have not yet had the opportunity, or for those listening in, I will begin by saying a few words about rulemaking and the purpose of advisory committee meetings. The purpose of an advisory committee is to increase the public's involvement in the drafting and development of administrative rules. The Oregon legislature, through its enactment of the Administrative Procedures Act, ORS Chapter 183, stresses the critical importance of the public's participation in policy development. Advisory committees are an excellent way to solicit input from internal and external stakeholders who are likely to be impacted by the development or amendment of agency policy and rule. Consequently, advisory committee invitees may include licensees, permittees, industry representatives, OLCC staff, members of law enforcement, local government, the public, local community organizations, small businesses, and other interested stakeholders. The purpose of having all of the members on this committee today is to hear from different parts of the industry and public health and safety partners. The commission strives to hear from all interested parties. Our role today will be to explain the background and context of these rules and the changes that are being proposed in this package. We will provide facilitation to ensure that all committee members can provide input today. During this afternoon's meeting, we will seek your input on the proposed amendments to the marijuana retailer tax compliance. Today's staff will explain the proposed amendments to 6 existing rules in response to Governor Kotek's directive for the OLCC to require proof of tax compliance for marijuana retailers as part of the renewal, change of ownership, addition of license holders, and/or new licensure process. Under Oregon's public meeting law, this meeting is open to the public, and members of the public are free to observe our discussion but may not offer comments. The agency will digitally record this advisory committee meeting and will produce and circulate a record of our discussion. However, because this meeting is intended to promote the open exchange of ideas, we will maintain an informal atmosphere, and meeting minutes will record only the topics discussed and the main points made. We will now move on to introductions. I will call on your name. Please introduce yourself with your name and organization that you are representing. Again, Nicole Blase with the OLCC. Amanda?
Amanda Bork, Policy Analyst with OLCC.
Okay, and I'm looking for OLCC staff that we have on the, Danica, are you there?
Hi, Danica Foster, Director of Licensing.
Great, thanks, Danica. Melanie?
Melanie Musial, Director of Administrative Hearings Division with OLCC.
Thanks, Melanie. Nicole?
Nicole Mitchell, Marijuana Licensing Technician.
Thanks, Nicole. Denise?
Denise Byra, Marijuana Licensing Technician.
All right, thank you. And I will move to the RAC list with all of our RAC members.
Hey, Nicole. Patrick Owen, recreational marijuana licensing manager.
Thank you, Patrick. I didn't see you there.
Okay,
Uh,
thanks.
Ferdy, go ahead, sorry.
Ferdy Ruckland, attorney at Tom and Schwartz, and chair of the Cannabis Practice Group.
Thank you. Gabe.
Gabe Partonley, general counsel of Wild.
Thanks, Gabe. Hunter.
Hunter Neubauer, Oregon Industries co-founder.
Thank you. Anthony Taylor.
Yes, thank you. Anthony Taylor, Chair of the Oregon Cannabis Commission.
Thank you. Alex Berger.
Alex Berger, attorney with the Merge Law Group.
Thank you, Alex. Justin Hobson.
Hello, Justin Hobson, attorney with Nordash.
Thank you. Aaron Purchase.
Hello, I'm Erin Purchase, owner of Kind Leaf Pendleton LLC.
Thank you, Aaron. Margot Lucas. Kelvin Atkins Helgeson.
Hi, I hope. Kelvin Atkins Helgeson with the Oregon Department of Revenue. I'm a policy analyst.
Great, thanks, Kelvin. And Scott Winkles. Okay, thank you everyone again for joining us today. We only have an hour for today, so we are going to move pretty quickly. I believe Danica Foster is going to go through the proposed rule language. And then after that, we will have a little bit of time for discussion and possibly fiscal impact. So I will turn it over to Danica to get started.
Thanks, Nicole. I'm actually going to have Patrick Owen take that today.
Oh, great.
Thanks. Hello again, Patrick Owen, licensing manager for the marijuana program here at OLCC. The draft we have up on the screen there, and the copy you may have, has, in addition to the tax certificate of tax compliance amendments to the rules, also several technical rules which were discussed in this morning's RAC. So we will be skipping over some sections that don't apply to this conversation. The first on my list is within the definitions section, which is OAR 84502511015, paragraph 19, which just defines what a certificate of tax compliance is. So this describes the certificate of tax compliance as the certificate that is provided by the Department of Revenue, demonstrating a person or business's compliance with applicable tax rules. That doesn't necessarily mean everything's paid up, because one can be in compliance whilst still having a operating under a payment plan. The next section I have is under our application process, which is 845-025-1030, specifically paragraph 3.
For everybody who
Well, paragraph 3 and then sub paragraphs, which, thank you, we have up on the screen there, which is G and H. So this just defines the timeline. The reason for these two portions is because when the rules went into effect, the temporary rules went into effect, there were a number of licensees who were going to need to go through renewal. And we didn't want somebody who was, maybe halfway to that process to have to immediately supply the certificates. So the intent here was that nobody would be sort of impacted midstream, which is why you see these two sets of dates here. So after the operational dates, all marijuana retailers for both renewals and new applications will be required to provide certificates of tax compliance. You may also see the language here that the certificate must have been issued within 90 calendar days of the date the initial application was submitted. What that means is no more than 90 days prior to the date the application is submitted. Reason being, a certificate of tax compliance from, say, a year and a half ago may no longer be really demonstrating the current state of the situation. We can move on. I do not have the next section noted. Do you, Nicole?
Sorry, Amanda's taking the wheel on
Or
screen.
Amanda, sorry, I didn't know who was controlling the screen.
It's 1165.
Thank you.
Actually, excuse me, there's a little bit prior to that. There's a little bit at the end of the rule we were just on, saying that the application will be considered incomplete if they're not submitted with the application. And then after that, it goes to 1165, which is changes of business structure.
All right, so did everybody get that? A application that is submitted without all required certificates of tax compliance is considered incomplete. And then 1165. So in addition to new applications and renewals, changes to business structure, that would be anytime somebody is adding a new partner who would be considered an applicant. Those applicants who would be added would also need to supply certificates of tax compliance as part of the change of business structure.
And Patrick, before you go on, you might want to mention that the rules as they are currently are just for retailers, but these rules contemplate all of our license types in the future.
Yes, thank you. So the temporary rules that are in effect currently, yes, are affecting retailers. Permanent rules beginning next year would be affecting all license types potentially.
$100 order.
See the on or after July 1st date. I'm sorry, I cut somebody off. Who was that?
$100 with order. What do you mean by potentially? Yes or no, or maybe? What is potentially?
I apologize. I should not have said it potentially. So you'll see here, it's next year. So specifically what we have on the screen here, the paragraph capital C, on or after July 1st, 2024, any licensee or laboratory licensee proposing a change of business structure would need to supply these, and those dates are similar if we want to go back up to 10/30. You'll see similar language here. So on and after July 1st, 2024, a certificate of tax compliance for each applicant as described previously. So it's going to be required for all license types.
I have a question on that. Gabe Parton, since the folks from the DOR are here as well, I understand that this is the certificate of tax compliance is coming into play for all businesses in the state of Oregon, or a lot of different businesses. Can you provide a little context on that? I know that there's a RAC coming up on Thursday that's related here.
Yeah, can I ask who's speaking?
Gabe Parton from Wild.
Thank you, Dave. I don't have a good view of the room from here. So I think Kelvin from Smart. Go ahead.
Yeah, sorry, raising my hand and unmuting my phone. Thank you. This is Kelvin Adkins Helgeson from the Department of Revenue. Gabe, nice to talk to you today, and I look forward to seeing you Thursday. We will be having a rule advisory committee for when the Department of Revenue will issue certificate of tax compliance to any business or individual that would request one. That rule, as proposed, would apply whether you were a retailer, processor, or producer. Generally speaking, there are multiple professional or business licenses that require a certificate of tax compliance under current law for a variety of different licensing agencies, including DHS, child care providing agencies, as well as the Department of Public Safety and Standards. They're providing or requiring them for, private security firms. There's a whole long list, which we're going to talk about Thursday in more detail, but our rule is generally applicable to all business types.
And to follow up on that, Gabe again from Wild, is that for them to keep their license or is that just a general request? Because as I understand it from, there's certificates of tax compliance generally as a component that you can request, in order to buy a business or whatever, to, as the, make sure that the business is in tax compliance, the DOR approves that. But in order to maintain a license or renew a license or get a license originally, it sounds like childcare and people that, or then DPSS. Any other, like, is there a common thread between them? Is it have some degree of fiduciary duty to the state? What's the, where's the thread there?
Yeah, I think that we are seeing an expansion of that from initially the department ran a pilot program on tax compliance certificates as a prerequisite about almost a decade ago at this point that applied to plumbing licenses. There is continued movement for requiring these for any licenses. That's not, the department does not require these licenses. It's individual licensing agencies, which I know you get the nuance on that and everything. But I think so generally, yes, there's no common thread between where it's required. It's at the discretion of the licensing agency.
Okay, thank you. And then Dave, again, I'm gonna pass this back to the OLCC. Is there a similar thing coming into play for alcohol or for like bottle bill depository?
That's really outside the scope of this conversation. But if you'd like to discuss separately, we can have somebody touch base with you afterwards.
Thank you.
All right. Let's see. Where did that leave us at numerically? Thank you. Application process.
No, I went backwards, Patrick. Give me a second.
Yeah. Well, I asked you to, so thank you.
So this was change of business structure.
All right. Thank you, Amanda. So again, Patrick Owen, licensing manager. So 1165, that is our change of business structure. Again, adding new partners who would obtain a licensable interest or otherwise be considered licensees. Also have to supply that documentation in order to actually gain, to be considered licensees. Separately, the change of business structure application would be considered incomplete without those, so it wouldn't be considered validly submitted. We can move on, I think, to 1170.
Hunter Neubauer here from Oregon. I just have a quick question, kind of follows what Gabe was talking about. In the other licensed agencies that are requiring a tax certificate, are they requiring the ownership or applicant's personal income tax compliance, or is it just the health of the business and the state taxes that it should be paying?
So you're asking for not OLCC licensees, but other licensed businesses. So
yeah, I'm essentially looking at the fairness.
Hi, this is
Kelvin. Yeah.
Sorry, Patrick. So this is Kelvin Adkins Helgeson with the Oregon Department of Revenue. Yes, other licensees do require the personal income, pardon me, the personal income tax of owners or officers within their licensing. It ultimately would depend on what is required by the different licensing agency. The department can, do an individual tax compliance certificate or one for the business, or in the case of the OLCC rule, anyone who's deemed an applicant we would be able to certify that compliance.
Okay, quick follow-up. So if an applicant is an out-of-state
Mhm.
applicant, are you going to be requiring that said state to provide a tax compliance letter to the OLCC and to the Department of Revenue?
Patrick, I don't know if that's entirely a
I
question.
can
for-
probably respond to that, and you can you can fill in the gaps, Kelvin, if necessary. So again, Patrick Owen, licensing manager, OLCC. As it stands currently, the certificate of tax compliance that OLCC receives from the Department of Revenue, or as provided by the applicant once they receive it from the Department of Revenue, relates only to the taxes that the Oregon Department of Revenue is responsible for administering. That is, taxes due in Oregon. It may include local jurisdictional taxes if those taxes are handled by DOR, but it does not include out-of-state taxes.
I would just raise concern there. That seems a little off, in my opinion.
You would, are you saying it seems off that we're not considering compliance with other state taxes?
It seems like we're just targeting Oregonians. If there's applicants that are from other states and live in other states, and they're not being required.
Okay, that is a good comment. Thank you.
So it seems destructive.
This is TJ Sheehy with OLCC. I wasn't here for the intros. Hunter, in your mind, how would that work to equalize?
I don't know. That's what I'm saying. To me, it just.
I think Alex Berger, I think I can speak to those concerns. I think the concerns are Oregon agencies discriminating against their own residents, right? In that Oregonians, by virtue of living here, would be disadvantaged as compared to owners who live out of state and don't have to provide.
Right.
Which
I think we see what you're saying here. You know, any a person who is non-compliant with Oregon taxes would definitely have more trouble getting a certificate of tax compliance for Oregon taxes than somebody who was not delinquent on any Oregon taxes or otherwise not compliant, even if they were delinquent in taxes in other jurisdictions outside of Oregon.
Yeah, this is Alex Berger again. That's the point I'm trying to make. And I think it raises constitutional concerns in terms of, you know, the federal commerce clause. And it's interesting, I've seen cases where states have discriminated against residents of other states to the advantage of their own residents, but I've never seen it in reverse before, which I don't think is a great precedent to set, but it certainly would be an interesting case. And I wonder if there's something similar in the Oregon Constitution as well. I'm not a constitutional scholar, but it does raise concerns that a state agency seems to be discriminating against its own residents to the advantage of out-of-state owners.
These are good comments. They are being recorded. These are not things we probably have full conversations and answers to at the moment. But as the purpose of the Rules Advisory Committee is to collect discussion and comments, and then return to rule drafting and make revisions or adjustments once considering those. So these are great points, and thank you very much for sharing them.
Justin Hobson, Northern Nash, just to dovetail on Alex's comments, I think by way of example, if you had two retail licensees that are C corporations, the C corporation may be able to obtain a tax compliance certificate, but if they're solely owned, one by an in-state resident and one by an out-of-state resident, the in-state resident may not be able to obtain that tax compliance certificate because of whatever reason, but the similarly situated out-of-state resident that may have personal income tax liabilities in that state isn't going to, they're going to receive an Oregon tax compliance certificate because they don't have any Oregon tax liabilities. So one continues to be licensed and the other does not.
This is TJ with OLCC, so not a lawyer, not an accountant. But if income taxes were taken off the table, wouldn't that create a situation where like it would create an incentive for people to incorporate as S corps or other whatever else passes on to their personal income tax, so that they could be delinquent on business taxes, but it would show up on their personal return, therefore find
So Justin Hobson, Northern Ash again. I think it would actually incentivize businesses to incorporate C corporations because just by way of background, the C corporation is a tax-paying entity. It's not a flow through. Any income taxes are going to be paid by the entity itself. A partnership, an S corp, sole proprietorship, the income taxes would flow through on a K-1 or be directly reported on a 1040. And so an out-of-state resident has an incentive to ensure that all those taxes are trapped within Oregon, and then any of their other liabilities from out-of-state activities or unrelated to their marijuana or cannabis investments don't show up and don't preclude them from obtaining the tax compliance.
Well, sorry, and to clarify, this is TJ with OLCC. I'm talking about the in-state businesses by taking, I mean, what I think I'm hearing is the feedback is take income tax out of the check. Because it's logistically basically impossible to check income tax for out-of-state people. But by taking income tax out of the check, even for in-state folks, doesn't that then create a system where the in-state folks would pass it through to their personal income tax and skate on the taxes?
Justin Hobson again, Northern Ash. No, because the way the draft rules are currently written, the licensee as well as anybody who's listed as an applicant would be required to provide that. So if it's flowing through, the applicant in that process, in that structure would still be required to get the compliance certificate. I guess stepping back a little bit, I think there's a huge distinction between the marijuana retail sales tax that are collected and remitted by retail licensees and income taxes, right? So one of the areas where tax compliance certificates are relevant that hasn't been mentioned are for lottery businesses. So if you're collecting cash from or whatever from customers and then selling lottery tickets, you're essentially taking money that belongs to the state and then supposedly remitting it. And that's, I think there's a fundamental difference because there's similarities with the marijuana retail sales tax where our retailers are out there collecting funds that don't belong to them. They belong to the state. And income taxes, which there's just a fundamental difference given the nature of what they're doing, how income taxes are calculated vis-a-vis retail sales tax. And so I think from my standpoint, it's much easier and much fairer if we limit the scope of the retail or of the tax compliance certificates to retail sales taxes and not expand it to other types of taxes.
All right, looks like Kelvin, you have your hand raised.
Alex Berger agrees with that statement wholeheartedly.
As do I.
So,
Go ahead.
sorry,
Kelvin.
this is Kelvin Atkins-Helgeson with the Oregon Department of Revenue. There are additional trust taxes that apply to entities other than retailers, such as the income tax withholding program. And that is where individual tax of employees is withheld at the point of payment of wages and then remitted to the Department of Revenue. And when an entity does not do that, the department can pierce the corporate veil. But to say that non-retail entities don't have trust taxes is not entirely accurate.
This is Alex Berger. I think the distinction is when we're talking about personal income taxes. And, I think that is an issue for a number of reasons. One, I'm not sure that whereas 75C grants OLCC the authority to require personal income tax compliance.
I would like to interject here. This is Patrick Owen again with OLCC. So as I understand it, Kelvin, DOR is having its own rack on the issue, like how the certificates of tax compliance are issued. Is that correct?
That's correct.
Okay. So OLCC's rules are not specifically saying one way or the other whether demonstration of compliance with personal income tax is required as part of this. Our rules are actually just saying that we need the certification of tax compliance from the Department of Revenue, from the people who would be applicants. So how that certificate is issued and what considerations are made for it might be a better discussion for that other rules advisory committee, because we really don't have, we can't direct the Department of Revenue to do it one way or the other with our rules.
This is Alex Berger. I disagree because of the nature of what an applicant is. An applicant includes an individual who be a business owner whatsoever, right? And so if they have to provide a tax compliance certificate, I mean, that only reasonably refers to personal income tax. So I think it is within the scope in terms of who has to provide a tax compliance certificate. And again, I don't see anywhere in ORS 475C that gives OLCC the authority to require that at the penalty of not renewing a license.
And Kelvin, I see your hand still up. Did you have a comment or did you just forget to put it down?
That forgetting to put it down, I guess my comment would generally be in lines with the understanding of the department doesn't define an applicant who's required to provide the certificate. We'll just issue it under the circumstances that they filed all required returns and reports for the last 3 years and paid or have a payment plan. So, you know, we would not be in a position to say, as the department, all required applicants have applied to us. We'll just issue certificates as the requests come in.
But the review for certificates doesn't, this is Patrick Owen again, does include personal income taxes, is that right?
It may, depending on the nature of the request that we receive. So if it's for the individual and the business, or if it's just for like an individual.
And so and I'm sorry, was that Hunter who was speaking previously?
That's Alex.
Alex Berger, I'm sorry. So to Alex's point then, if it didn't include personal income tax, then there wouldn't be really on the individual level anything to demonstrate, because otherwise we'd be requiring it only for business entities, limited liability companies, corporations.
That tax certificates are required for entity applicants.
Pretty welcome from tongue, and I agree with Alex Berger.
But this is Alex Berger again. Sorry, I don't mean to monopolize it all. That is at the bare minimum, because again, I think OLCC's authority under ORS 475C refers only to marijuana licensing related matters, which in this case would only be the retail sales tax, which is, I believe, what Governor Kotek directed in the first place. I don't think any mention of any other license type was ever mentioned in that directive, at least nothing public. And, you know, I think that OLCC should stick to its authority and should narrow the scope to retail taxes for, you know, all of the reasons that were listed here, especially Justin's, regarding the fact that that retailers are just stewards of Oregon's money.
TJ with OLCC. So Alex, on your last point that it should only be required for entities, and again, not a lawyer, not an accountant, well, how would that work for sole props?
How many are there?
I have to, I mean, on the producer side, I think it's weighted more heavily. We have more sole props among producers than we do other license types, I believe, but.
That is true.
Then I would refer back to my previous statement that it should be restricted to retailers. Yeah. Anyway.
But let's for the sake of discussion and making sure a workable rule is passed, regardless of which way that decision point is made. If it were applied to all license types, how would the statement of it should only be required of entities work with sole props?
Revise it to entities or sole proprietorships.
I mean, this gave from Wild. This is not asking for legal advice, but lawyers in the room. If you're declaring yourself a sole prop, are you declaring yourself to be a business as an individual?
I think that's adjusting.
That's like an opt-in, right?
First, so Justin Hobson, Miller Nash, for a sole proprietorship, any of the marijuana-related activities as arising from their license are going to be reported directly on their personal income tax returns on 1040.
Yeah.
That would be subject to the tax compliance certificate. I think some of this gets into the nuance of what is an applicant, and I think the preference that Alex is trying to make is only the licensee should be the one required to provide the tax compliance certificate, whether it's an individual, an LLC, a corporation, or something else. If we try and narrow that scope, I think the concern from the industry side is what happens if we have passive investors who live out of state or in state, and they have tax issues that are completely unrelated to their ownership of a licensed entity that cause problems. And the rules as drafted swallow those types of passive investors up and potentially limit their ability or prohibit their ability to maintain and retain licenses. And I don't see that falling within the scope of the rule or the intent of the rule.
Alex Berger, the same would be true for a landlord, for example, that is receiving a certain percentage of profits, or a service provider, or somebody else who is unrelated to the business and has no decision-making in terms of the retail sales tax or bank taxes in general.
This is Patrick Owen with OLCC again. I think this is a good point, and I did want to get to whom this would actually apply, just clarifying, who is considered an applicant and licensee under our rules, because in many cases, those passive investors are not necessarily. Now, I suspect the people speaking to that know exactly who they're talking about, and however, I don't know that everybody necessarily does. So I would like to get to that. That being said, we have about 23 minutes left. And there's 2 more rule sections, including the renewals. The comments have been recorded. The points made about to whom they may apply and whether or not the authority should be extended or does in fact extend far enough to capture the things we're talking about here. Those all will be discussed. But let's move on at least to the remaining sections, which are 1170, 1190, and then we can clarify to whom this applies and continue discussion with any time left. Does that sound okay?
Yep.
All right, thank you. So moving on then to 1170, which is covering changes of ownership. Very similar language here. So for retailer licensees, we have the first paragraph, which is incorporating the temporary rules into permanent, and then in subparagraph B, we have on and after July 1st, that would be extended to all license types. So this is for change of ownerships. This is, before we scroll away from that though, I think it's important to point out. So this rule as it's written currently says the certificates must be submitted for each current licensee as well as since it would also be a new application for the buyers. So both the current licensee for any change of ownership and the new licensees would need to demonstrate tax compliance before a change of ownership would be approved.
Gabe Bartonley, I'm gonna point out that this does exactly what Justin sort of mentioned and what Hunter mentioned, as well as that this allows Canadian companies to just buy up Oregon assets with no concerns and no oversight from this specific provision.
All right, thank you for the comment.
Alex Berger, the only thing I would add to that as well is that, for those who obtained licenses before this rule, they had an asset that they could sell under most circumstances, and this would remove the value of that asset if, again, a passive owner or someone else that couldn't necessarily be gotten a hold of, or some service provider or something else was not meeting their personal income tax obligations, and it would reduce their investment backed asset to $0.
All right, thank you. Moving on, still within this section, paragraph 6, this is stating that the commission shall deem a change of ownership that's submitted without all of the required information to be incomplete. That is, it's not a denial, it's the application was not completed. A determination that an application is incomplete can generally be, one can request reconsideration, although with a change of ownership, one can also reapply.
This is Alec Berger. Sorry, this is a concern as well. Just because I think that in most, if not all of the circumstances where a license may not be renewed or an application may be refused, that the applicant should have hearing rights under the APA. And I think that is required under 475C.033 sub 3, because I don't think it is a question of the form of the application. I think it's a question of the substance of the application. And so I think that OLCC should be concerned that if the rule is passed as proposed, the denial of contested case hearing rights may violate the APA.
All right, thank you. This is the last of the specific rule sections, so 1190 license renewal. Some technical language changes here, which are not really part of what we're discussing. Let's see, where is that? I think it's the last two paragraphs in here. Oh, there we go. So similar, and your point also would apply here. A renewal application is only going to be considered complete if the certificates of tax compliance for the applicant, for the licensees, are submitted. In addition, for renewals, if those certificates are not received by the date of expiration, the license, because the application will be considered incomplete, temporary authority will not extend, will not be extended, which is to say the license will be considered expired at that point. Licensees still have a 30-day window to renew after, to do a late renewal after expiration. And that same 30-day window includes providing any remaining certificates of tax compliance that would be required. I see a hand up. I'm sure there's comments on this, but I do see a hand up from Kelvin, so I'd like to let him chime in.
Hi, Kelvin Atkins, Elderson, Department of Revenue. This comment will not be one of the fun ones, I'm sure. It looks like there's a typo in 2C of the rule. I think it's intended to read June 30th, and it's just a typo.
Oh. Thank you.
Good morning, Oregon. The industry would be in favor of extending the 90 days. There's obviously going to be a lot of potential conflicts and communication between different entities, different people, lawyers, regulatory agencies to get the certificate. 90 days seems like it's pretty quick. So if there's an opportunity to extend.
So that's the language here could be more clear, frankly, but the 90 days is the certificate needs to have been generated no more than 90 days prior. So afterwards, if it's still within a window by which we would accept it, then we would accept it. Now, if you're talking about extending the late renewal window, that's a slightly different discussion.
Alex Berger, I think the language should be changed to say prior, because lots of folks in the industry that I've talked to are like, oh, I have 90 days from my expiration date to obtain this thing. And that doesn't seem to be the case. But regardless of that, I would also push for extending that 90 days to at least 6 months, if not a year, just because I have a number of clients who have a lot of licenses, and if they have to go back, it's just a logistical nightmare, once they have one. And for the most part, I mean, at least personal income tax wise, I don't think anything is going to change. Of course, I want that stricken from the record completely. But I think, and it would also ease the burden of DOR to be to be looking into folks who have already gotten their compliance certificates, that every 90 days, when you know, on the 91st day, a new retailer license comes due, I think it makes sense to extend, just from a logistical standpoint, to at least 6 months.
Okay, thank you. So we've got about 15 minutes left. So who would this apply to, I think, is an important thing, and this is maybe a little, I mean, it's not opening those rules up, so I don't think you'll find them in here, but in our general rules, persons who are considered to be licensees or applicants are the licensee of record, which is typically the business name on the certificate. Any individuals or entities that own or control 20% or more of the company, and then those who are entitled to make decisions or enter into obligations on behalf of the company. And obviously I'm summarizing here. So let's say I have a passive investor who doesn't have, you know, they're passive, right? They're not involved in operations. They don't make decisions. They put money in, they have an investment, and they expect a return. And they've got, let's say it's a corporation and they own 10% of the stock. That person is not one of our licensees. They have a financial interest, but they're not a licensee and therefore not somebody who'd be getting a tax certificate from. Now, I don't know if that addresses any concern one way or the other, but I just wanted to make clear, you know, these documents are not going to be required from every single person that has financial interest in a company that has many, many investors.
Just Hobson, Miller Nash. One of the issues that I have with the rule itself is it relies on what isn't really a defined term, applicant. So in your example, 10%, if you bump that to 20, it does. But my understanding is the term applicant is not defined anywhere in the ORS or OARs, or if it is, it doesn't explicitly include the license itself. And so when I read these rules, it's not clear to me that it actually applies to the licensee. It's only the applicant. And anywhere I can find the defined term applicant, it's not clear to me that that's the licensee. Just purely just kind of looking at it from a statutory construction standpoint, I think one thing would be helpful to clearly define applicant in the rules.
It is defined, however, it is defined not within the definitions section, which you raise an excellent point.
It's defined similar to the Washington rules for true party of interest, and it sort of explains it by saying it includes these certain types of individuals, whether it's 20% or having an interest in the profits of the business. And there's sort of an enumerated list, but none of those items in the list include the licensee itself.
All right. There's a good comment. There's a good.
Alex Berger, it doesn't really assuage my concerns much because there are plenty of passive investors that own 20% or more. And then there are entities or complicated structured ownership structures. And then we're looking at managers of those entities, and some entities manage other entities, and they're managers of those entities. And it really can involve a large number of individuals who the actual licensee of record, which is responsible for paying the retail sales tax, for example, don't necessarily have any control over those people. They certainly don't have control over people who are providing services for 20% or more profits or revenue. And I can't say it more plainly enough that based on the governor's direction and the authority that OLCC actually has to impose this rule, I renew my recommendation that it be narrowed to retailer licensee of records and apply only to the retail sales tax.
That comment's been received and recorded, and I don't mean to sound how I probably sound, but I think that point has. You are heard is what I like. I want to confirm that has been heard.
I appreciate that.
I have a comment just from a practical perspective and a request for an additional carve out here for each one of these rules. Because, you know, I'm gonna bring it up in the RAC, relating to the certificates of compliance and how those are defined in at the DOR level, but I'd like to specifically bring it up here because it really matters for our industry. We don't have access to like normal servicers, so like payroll tax managers and payroll companies kind of suck when it comes to who we have to deal with. And I know for us, like, we're on the non-compliant tax list right now as a company because our third-party payroll tax manager misfiled our taxes. And so with how, like, we're dealing with it, but it's taking longer than we want it to. And the DOR knows who this company is because they've bungled it on a couple of different occasions with a couple of different companies. And, you know, they said there's like 20 companies that are asking about this. And I wouldn't be surprised if most of them are cannabis companies. And so while, you know, if this is applied industry-wide, I'd ask for some, you know, something that allows a good faith, you know, discussion that's ongoing with the DOR as an addition to the certificate of compliance and payment plan. So certificate of compliance as is paid up to date or you're under a payment plan. As a business, I'm not entering into a payment plan or paying taxes that I don't owe. That's crazy. And in order to get a certificate of compliance. So unwinding what's going wrong with our payroll tax management company has taken about 60 days at this point so far. It's still going on. And then unwinding that with the DOR is even longer. And we don't want to have a tax appeal out of it. We don't want to create a case where we can just resolve this directly. And so, you know, this plays to the time limits. This plays to the, you know, the yes or no for what a certificate of tax compliance is. And this would be a request, you know, just because of the industry that we're dealing with and the incapacity for us to deal with real, you know, professional servicers, to have some wiggle room, other exception that would allow us to have this, you know, conversation. I know that the, you know, the rule, the last piece in renewals allows for like, you know, a written contest that doesn't fall within the contested case hearings. But that really, really leaves it outside of the hands of the industry to do anything about it. And so being, you know, kind of saddled with the situation as is, you know, the request is that the regulations sort of direct to the system as is right now and allow us that a little bit of grace here.
Alex Berger, just to dovetail on that really quickly, another way of putting it, I think, is that it leaves all discretion with the DOR. And there may be some cases where an applicant entity has provided the back tax returns, you know, there might be a large number of them, who knows? But, you know, this could be 10 days prior to the expiration date, and DOR just doesn't have the bandwidth to process each one of those returns, where technically DOR was given everything they need, and, you know, the applicant could be out of luck if those returns are not processed. So some sort of mechanism by which an applicant can show good faith proof of providing these returns or whatever else is requested by DOR would be helpful in terms of not having to shut down your retailer for that 30-day period to renew.
Patrick Owen, OLCC. I mean, obviously the comments have been received here. I see your hand up, Aaron. I would reiterate what I said earlier. Those comments might be good to also ensure are reiterated within the Department of Revenue's RAC, although Kelvin, you're here, so you've heard them.
I'm not on that rec, so I thought
I know everybody's, it's not a one-to-one on who's there, which is why I mention it.
Yeah, This is Gabe again. I will raise it at the DOR, but I'm raising it here because, this is, as Kelvin mentioned, this is something that's driven by the agency with regard to control of its licensees. And so in this particular case, because of the type of licensees that it's being imposed on, that's what we're asking for this specific carve out.
It's Patrick Owen again. I didn't mean to sound dismissive. I just wanted to point out that is commentary that is probably very, very useful in that other RAC. I want to recognize Erin, who put her hand up. Please go ahead.
I just wanted to show my support in the longer than 90 days or some sort of grace period to allow the retailer to prove to the OLCC that they are doing something to get all partners, entities, and licensee into compliance, because I think that there are a lot of businesses right now that have complicated structures. My business itself has a complicated structure, and we go through a lot with attorneys, which take greater than 90 days almost every time. And then after we get these entities in compliance, we have to rely on the individual partners and entity owners to submit tax returns, compliance of their personal tax returns. It leaves us about 60 days to do something such as an involuntary withdrawal, which is a huge legal matter that could end up all the way in court trying to push a partner who is not providing a tax compliance out. And we don't want to shut down Oregon businesses over one partner when they are showing good faith effort to do what it takes. It's also very expensive to the retailer to go through something like this. So I just wanted to support that there should either be like a 6-month period for that submission, or the expiration date on the tax compliance, and then also some sort of leeway or grace period and the ability to submit proof of what you are doing to become compliant, so we don't push people out who have been here all along.
All right, thank you very much for that. So we have about 3 minutes left. Nicole, you just put some information in the chat. Kelvin, if it's quick, I think we have room for one more comment before we have to wrap up.
Department of Revenue, we support the use of tax compliance certificates to support the financial security revenue, and it has been successful already in getting businesses into payment plans that were previously not in payment plans. It's worked for other industries for quite a while. Many who are similarly complicated in structure or owned by individuals. We think that it is good policy to consider this rulemaking. Thank you.
Alex Berger, I want to push back on that for just 1 second. When when I helped a client apply for a tax compliance certificate, I was told that there was no mechanism for an individual non-business owner to receive a tax certificate. And so that suggests to me that this is applying only to OLCC licensees this time and not other industries. But I could have that wrong, but I was just told that, we had to send in the individual form for this person because typically this was only done for businesses and perhaps sole proprietorships too. I'm not sure, but I am not a lottery law expert or an expert in those other industries, but from what I understand, based on the unique definition of an OLCC applicant, this applies differently to this industry than other industries.
Justin Hobson, if I may, I hear the department's position that having programs like this helps compliance, but I think it puts undue pressure on our licensees to concede tax issues that are legitimately in play for the sole purpose of coming into compliance, getting a certificate, and just paying it because they're under duress, because if they cannot come into compliance or get that payment plan for legitimately disputed taxes, they're going to lose their license. And that is not the position the state should be in. They shouldn't use a legitimate tax dispute as leverage to preclude Oregonians or anyone else from doing any sort of licensed activity.
And Hunter Neubauer, Oregon, and I'd like to say from the industry perspective that this has created a scenario in the marketplace where businesses are no longer paying their vendors. They're saving money, they're not paying rent, they're refusing to pay bills so that they can somehow come into tax compliance instead of pay the folks that are providing them with products. They're taking the money, selling the product, and then not actually paying for it. So there's.
Thank you very much. I think we are out of time. Nicole,
we are going to conclude for today. So thank you so much, everyone, for joining us today. For the RAC members, in the meeting materials email that you received, there's also a fiscal impact statement. If anybody would like to expand or provide more information on possible fiscal impacts of these changes, please fill out the form and send it to me by Friday if you can. We also welcome any other comments, suggestions in our olcc.rulemaking@oregon.gov email box. So thank you so much to everyone.
What is the public comment period?
That has not been released or announced yet, but it will be tentatively in October, and that will be, everybody will be made aware of when that will be. Yes.
Thanks, everybody. The Department of Revenue is having a RAC on Thursday. We couldn't have everyone, the member that may have wanted to attend, but it should be on our website, and members of the public will have time to provide comment as well.
Thank you, Melvin. Thanks, everyone.
Thank you.
thank you.